Hello.
Angel Jackson, can you hear me?
Yes, I can.
Okay. Mr. Arkanicki coming today?
Cindy Mannon, Your Honor, covering for Mr. Akanicki.
Okay, Ms. Jackson, do you have an attorney representing you?
No, I don't.
Okay, I'm gonna put you in the private meeting room with the plaintiff's attorney to see if you all can resolve this matter. Okay?
Okay.
Thank you.
No problem. Alina Adams? Yes. Okay. Tamikia Gibbs failed to appear, so you can submit default, okay?
Termination, what she does. So I'll take that for you, okay?
On the record in the matter of Joy Monroe versus Tay Mitchell, file number 23-02136. State your name, please.
Joy Monroe.
Your name, please. Okay, today's the date and the time that's set for hearing on an eviction for termination of tenancy. And did you all have an opportunity to discuss this matter before I called this case?
No.
Okay, so you've not discussed resolution at all? Okay, and are you willing to discuss resolution?
Oh, no, she said she don't want to.
Okay, I didn't know that she said she didn't want to. You say, okay, you want to proceed to a hearing? Okay, and this is termination of tenancy. She did file an answer to complaint to recover possession of property, but we received that today. Did you get a copy of that?
What he just gave me?
I don't know
What
who
was
gave you. It should be entitled answer to complaint to recovery or to recover possession of property.
Yes,
Okay, and have you reviewed it?
yes.
You're disagreeing that the plaintiff kept the residential property fit for the use intended
Yes.
and reasonable repair? Okay. Do you have evidence that supports that?
Yeah, I sent them to your email.
Okay, when did you do that?
Yeah?
Yes.
Yes.
Okay, did you bring it in court with you?
No, I didn't.
Why did you send it to the email?
Oh, because that's what the lawyer told me to do.
What lawyer?
The lady from, her name is Elizabeth Paul, and she gave me the email to send to everything over there.
Okay, well, she shouldn't have told you that because you don't just send evidence to my courtroom. That's not how we present evidence in court.
Oh,
If you want to present evidence, you would need to present it at a hearing or at a trial. And you need to serve her with a copy of whatever you wanted to use as evidence. But your claim here is that there's been a breach of habitability essentially. And is legal services going to represent you or they just was assisting you?
They was assisting me.
Okay, so you're prepared to present your case today?
I guess not.
Okay. Well, you have some evidence, do we have evidence in the?
There's all kinds of stuff, pictures.
Okay, so you emailed a bunch of pictures and stuff.
To the, yep, to the email.
Okay, you can forward it to me.
That Judge Simmons, that courtroom, courtroom.
You said he received it. What I'm saying is that it's not proper for the legal services to be giving you our court email to send evidence.
Oh.
That's what
okay.
I was saying.
Oh, okay.
But you wouldn't have known that. Okay, you can proceed with your case, ma'am.
Okay, I haven't received rent from Tay Mitchell since December 1st, 2022. So we're going on a year. And then she sent a check. $850, and then she stopped paying on the check. But anyway.
When did she send that check?
Is February 23rd of 2023. And she stopped payment on it, so I don't understand how somebody want to live in a house if it's unfit. Why would you pay rent and then stop paying and then still live in the house?
Okay, and so you have not received any rent, although you did file for termination of tenancy, correct?
Yes.
Not non-payment of rent, okay. So you just want possession of your property, whether she pays the rent or not, correct?
Correct.
Okay, and you can make your defense, ma'am. Why do you believe that you should not have to be removed from the property? You can withhold possession of her property and then you don't have to pay your rent.
I didn't, I paid my rent and, where it stopped payment, that's 90 days after she did not cash the check, they stopped. The
Your
payment.
ringer on, ma'am, you need to turn it down, turn the ringers off.
They stopped the payment, not me, she didn't cash the check, and that's for February, but we're the one that for December and January.
So your position is that you paid your rent every month?
I did pay my rent.
Do you have proof of that?
Yes, I have. So after she said that she didn't receive the, those two payments, I did stop paying them, because how are you not receiving my rent? Like, this is the way I've been paying my rent all the time, and I've been living here 5 years, so,
It's all of the same things.
yeah. Sorry.
Okay, I have here what appears to be a check for $850 to Joy Monroe. February 23rd.
And then there should be another one before that, it's 1650.
This is February 23rd, okay, for $850. And then I do see another one. This is December 28th for $1650. How much is your rent each month?
$800, but I had a $50 late fee, but that was
Okay,
just
so this is for-
the 1650 was for December and January.
So December and January, and you paid your November rent, is what you're saying?
Yeah, before.
Okay, so December, you paid your December rent, you paid your position that you paid your December, January, and February,
Correct,
and a late fee for December.
yeah, for December, yeah.
And what happened with the other months?
The other month I didn't pay, because she told me that she didn't receive that money, so I didn't pay her.
So you're saying that since February, you've not sent any money?
No,
Where, did you put your money in escrow?
no, I have it in my bank account, though. I have,
You have proof that you put it in your bank account?
I don't have my bank statement, but I can get it.
Proof, and that's for every month from February till now?
Yeah, pretty much.
That's not pretty much, it's just, you have $800. So at this point, it'd be a late fee for each month, from the time that you last paid, which was February 2023 to now, which is November. You have that in your bank account?
Not until November, I don't, no.
Okay. You did not receive the 1650 check?
I did not. And when she sent payment, That last payment I did receive was like 1,600, it was like 1,000 something. The reason why that check was so big because she was like 3 months late, so she found some kind of organization to pay her rent.
She tell me
And
story.
then I was saying your rent is due in December. And then I had to text her and call her and she was like, it's in the mail. I haven't received payments, like I said, since 12/1/2022. And
Okay,
it's almost a year, so.
okay, and what you have here, well, I see where Case Credit Union cut a check. And it says on December 28th, 2022, payable to you for the amount of $16.50. Did anybody trace the check? And she said she didn't receive it. Did you have it traced?
I did, yeah.
And what
I
did the
did.
bank?
They said after 90 days, if she don't cash it, then they'll put it back in my account. If they
Okay.
don't find it, so
So they put it back in your account?
she didn't cash it, yeah, they did.
Okay, so why didn't you get her money after they put it back in your account?
Oh, I don't know, but she wasn't saying nothing to me, so I don't know,
Were you still
Okay.
staying in her house?
yeah.
Okay, what is the habitability issues that you are like?
Oh, there was a lot, my house is a fire hazard, the house is a fire, it's just a lot, it's not.
It's a fire hazard?
It is.
Why, you need to tell me what it is.
My city inspection came and they said that because my doors don't open and we can't get out the doors, we can only open the doors from
Which doors?
the bedroom doors.
The bedroom doors don't open?
No.
Why is that? What do you mean they don't open? You like stuck in the bedroom? I don't get it.
Yeah,
Are they, so do you keep them closed all the time?
no, you can't keep them closed, because the kids can't get out, if you keep the doors closed, can't. They
You
can't
keep
get out.
you keep the bedroom doors open?
Mhm.
Yes,
Yeah,
okay. And you notified her that the doors were not in proper working order?
yes, they did,
Who's they?
the city,
Well, that's hearsay. Do you have evidence that they notified her of that?
yes, it's in my email.
Which email?
The one from the city of Landlord.
You said, I have about 7, so
Yeah.
you're gonna have to tell me where I'm going.
All right. Try the 4414 Barclay PDF.
34. Okay, so I see here, code enforcement from 2018.
Oh, no, that's not the correct one.
I see one, failure to comply from 2020.
Yeah, that's it.
Failure to comply letter 2022. You have a valid rental certificate,
No, I don't.
ma'am?
I do, yes.
Where is it?
Oh,
Oh, I don't have it. It's still a rental property.
No, I'm
Yeah,
asking, was it
paid that.
valid? Because this tells me that in March of 2022, you received a failure to comply letter. I don't have anything that showed me that you brought it into compliance. Do you have something to show that you brought it into compliance?
Oh, no. But I mean, there is, because I worked it out. I mean, we did all the paperwork is done for Barclay. I called them and told them, because it's due for inspection now, but I told them the situation at the house is in court. And they said, right now, we're gonna hold off until I get this situated, and then
They're
we'll
gonna
go
hold
back
off on
to
what?
having the house inspection again, because right now it's not really a rental property.
Oh, that's because you don't
But
have a
the-
valid rental certificate, correct?
It's, yeah, I paid the fee to have the.
When did your rental certificate expire?
I don't have that with me.
So you don't know if you have a valid rental certificate?
I can get one, but I don't have it with me.
Well, that's not what I asked you. Do you currently possess a valid rental certificate, or was it either expired or revoked due to the condition of the property? Because I can verify this.
Okay.
So
I
want you to-
believe the
I want
house
you to
is-
answer. No, not what you should know, because you're the landlord and you're collecting rent. So I want you to tell me in court if
Yes,
you have a valid rental
I
certificate.
do. I don't have it with me though.
Okay, so you do, and so the January 9th, 2022, I'm sorry, March 9th, 2022, failure to comply letter that states that you're in violation of the Lansing Housing Code for failing to comply with the recent housing code correction notice, meaning they'd already sent you something, you failed to
Mhm.
comply. You brought that up to code?
Yes, I did.
It says, please sign and
I think it was
return,
about the furnace or something like that, but I did, yes.
please sign and return or call for reinspection.
Yeah.
And so you would have been re-inspected since they say your compliance date then was April of 2022. It's been over a year. So you should have had an inspection between now and then, correct?
All the inspection stuff is, yes,
When was your last inspection?
I'm due for one now.
When was your last inspection?
I don't have the correct date. I can't make up a date. It's like every 2 years, but I do not have the date.
Okay. Did you have an inspection in this year?
No, it's due this year,
Did you have an inspection last year?
no, 2 years ago.
Then you
It's
don't
like
have
every
a
2
valid
years.
certificate because if once you get a failure to comply, you
Mhm.
have to be re-inspected because
Right.
they
then I-
told,
yeah,
and you were supposed to call over a year ago
I did that.
for them to re-inspect.
hear
Don't
that.
talk over me. I don't know why people think it's okay to talk while I'm talking.
I took care of it though.
I want to see your certificate.
I don't have it with me.
If you can both have a seat, I'll call the case back in a moment. Both of you can have
Oh,
a
okay.
seat. I think he's on.
isn't a camera up here, so you've got to use.
Ms. Manon, are you ready to proceed with Angel Jackson? Muted, so I can't hear you.
All right, Ms. Jackson, we're gonna request an adjournment. She is unsure of who her landlord is, and she does have some money, but I think that she and Mr. Akanicki should get together and figure this out.
Okay, you need an adjournment for our next available date.
Thank you.
November 29th. November 29th at 2:30.
Thank you, Your Honor. I appreciate it.
Thanks.
Thank you, Thank you, Ms. Jackson.
Thank you.
Okay, back on the record in the matter of Monroe versus Mitchell. I did do a check. You do not have a valid certificate. It expired in March of 2022, but it's been an ongoing issue. It looks like with a failure to comply notice since 2020, and your last contact from the co-compliance in reference to your certificate was when they sent you that letter in March 2022 telling you to comply by April 2022, and now your rental certificate is on hold. So you do not have a valid rental certificate. This is not a rental. You were aware of that.
Actually, I was not.
You,
I just called and told her to hold off because I'm going to court over this
when
property.
did you call?
The last date I was here.
So you came to court September 12th and then you
Yep,
called
then when I
code
left.
compliance.
Yep, because I know I have the inspection coming up, because I just paid my inspection fee.
Okay, but you knew prior to that it expired in 2022.
And I did not.
Why did you not know that?
I paid for it and she said we was gonna do one. And I said, right now, the house isn't actually a rental property. I'm going to court for it. Can you, and she said, we'll put that on
Not
hold.
this year, I'm talking about last year. It expired last year,
I was not aware of that.
2022.
Okay, I was not aware of that.
And you never brought the issue that you got the letter for, you never brought it up to code. You were aware of that.
I did get a letter, but I sent it back in and we have to sign off and I sent it back to the office. So to my knowledge, everything is good.
And you have paperwork that reflects this, that you can bring to court to support what you're stating?
I believe I can.
Okay, I'm going to require you to bring me your paperwork. Otherwise, I'm dismissing your case if I find out that you're in court giving me information that you know is not to be true. I had to step off the bench and go look this up myself, because what I'm seeing here, based on the record she provided, is that there's not a valid rental certificate, that there was nothing that demonstrates that you even responded to the failure to comply, and that this was an ongoing issue. And that's the same information that's present. If you can pull it up on the public database with the valid rentals right now. The same information is reflected there.
So wouldn't the lady tell me that though on the phone when I asked her to put the
I
rental
can't speak-
inspection?
I
You know,
can't
she
speak
would
to
have
what the
said, well, you
lady,
don't have one already?
this lady right here is my court reporter.
Okay,
Her job is to take down everything that's being stated here today.
okay.
If I'm talking and then you
Okay.
start talking over me, even when you say okay while I'm talking,
Mhm.
she can't hear both of us at the same
Oh, okay.
time. So you can't do that, okay?
All right.
Thank you. So I can't speak to what someone who's not in court told you. It's hearsay, unless
Okay.
you. What did I just tell you? What happens when you do that?
No, don't say okay.
Thank you. You're talking over me. Okay, so now I can't speak to what this person who's not here in court told you. That's hearsay. If you want them to come and testify on your behalf as to what they told you, you need to subpoena them here for the next court date, okay? Is that a yes?
Yes.
Okay, and so I'm gonna give you a next court date because I'm gonna give you an opportunity to present evidence to show me that first, this was a valid rental certificate. Because as this hearing began, I was leaning in your favor
Mhm.
up until, because she hadn't paid any rent, she doesn't have any evidence for me to show me that she put it in escrow and she hasn't paid it for such a long time. Then as I'm scanning for the documents, I see some pictures. They're disturbing, to say the least, but I'm gonna give her an opportunity to present what those are. And then I see the information relative to the non-compliance. And then you don't have anything to show me that it's been brought into compliance. And I think you should have reasonably known or been on notice that that was gonna be an issue for you in court today. That you need to present me with evidence that this is first a valid rental certificate that you have. So I'm gonna give you an opportunity to bring that information and bring me any information you have to support you brought the property up into compliance. I don't care if it's receipts. I don't care if it's the people you brought to do the work. You need to bring me some evidence, and I need to see evidence from you that you have a valid rental certificate. And then, because right now it tells me your rental certificate is on hold and that it's been expired since 2022, not March 2023, last March, which was the same date of March 9th is the letter of non-compliance that she presented today in court. I don't know if you have all this evidence that she sent us. We're gonna need your email so that we can forward you the evidence that she's seeking to submit against you. That'll help you understand what evidence you're gonna probably need to bring me when I reset this, if you want me to rule in your favor. And I'm gonna allow you, I'm not gonna make you print all of that because that is a lot. I'll keep the emails, but what you're gonna need to do is you're gonna need to have some record of what I'm looking at. I can't keep going through 7 different emails to try to find what you're talking about. So you're gonna have to organize something so that when you're telling me, go into, this email, the third document, whatever you need to do to make it go more smoothly. We'll reset this so that you all can present your evidence in a more meaningful fashion, okay?
Is that the, so I have a question, John.
Yes.
So all the stuff that's on the list right now, so if she come and fix the stuff right now, does that mean that she fixing it, that she fixed it? Or
She owns the property. She can come and fix her property whenever. She still doesn't have a valid rental as far as I'm concerned, based on the information that I have before me, but she may have something otherwise, and maybe code compliance has an error. I don't know. If she comes and fix it, that doesn't have anything to do with my decision about your not paying rent between, it looks, what she's saying, December 2022 to present, okay? I still have to make a determination as to whether or not you lawfully withheld that rent, okay? And whether or not you owe her all, none, or a portion of that,
Right.
and whether or not you can hold over her property. So we'll make that decision after I hear some evidence, but I need her to bring me some evidence, and then I need you to organize your evidence, okay? Yes,
I
ma'am.
just want to make sure when I go down there, I need to get a valid certificate that is up to date.
You're bringing me proof that you have a valid rental certificate.
Okay.
Because you told me you had a valid rental and that you're coming up for an inspection.
So,
I need proof to show me that what it says on the website, which is that this expired in 2022, is an error.
2022.
Okay, you had a question?
I did, I had, so the inspection that I had in December, not December that just passed, but the previous December. I don't think that was in my, my thing neither.
I'm not sure. You haven't presented all your evidence. If you find more evidence that you want to present, you can always organize it and bring it. Every piece of evidence that you want to present, she needs to be able to see that. And so the best way is to email if that's working for you, because it's a lot. I will allow you to do that. You just need to be able to label it, okay, so that I know what I'm looking at and I know how to follow when you're giving your testimony about why the property was what it is. If you're talking about the doors, I need to see the pictures of the doors or whatever you're talking about. If you're talking about the certificate of compliance being revoked, I need to know where to find that, because right now I have about 10 emails and I could be searching all day trying to find what you're talking about, okay? So we're gonna reset this. It's gonna be November 29th at 2:30. You have any other questions? Ms. Monroe?
I do not.
Okay, you're all set for today.
Yes. Breakout.
Mr. Guskey's here. Using anything.
Martin Scott.
Okay, let's see. On the record, in the matter of Eagle Manor Estates versus Martin Scott, file number 23-02172. Council, may I have your appearance, please?
Good afternoon, Your Honor. Don Keskey for the plaintiff, and also on Zoom is Kip Wilson from Renaissance Property Management, which is the agent for the owner.
Okay, and sir, what's your name?
Martin Scott.
Okay, and Mr. Scott is present in the courtroom. Today was the date and the time that was set for a hearing. And this is for an eviction for termination of tenancy. Did the parties come to a resolution?
I believe so, Your Honor. I believe the parties have agreed that Mr. Scott would move out and vacate the premises on or by November 30th, 2023. And at present, he has a substantial rent balance of $6,084.64. Court costs of $157.96 for a total of $6,242.60, and no money judgment was requested.
Okay, so this was a consent judgment? Is that correct?
Yes, Your Honor.
Okay, so you want to enter into or have judgment enter against you by consent?
Consent.
Okay, you're consenting to that, sir?
Yes,
Okay, so you understand that you had certain rights. One was the right to be represented by an attorney at today's proceeding. Did you understand that?
yes.
You want to waive your right to be
Yes.
represented by counsel?
Yep.
Okay, you also have the right to have a jury trial. You have the right to demand your jury trial at your first hearing, or you could have filed a written demand and paid a jury fee or filed for a waiver of that fee. You did not do that, to the best of my knowledge. Are you waiving your right to a jury trial in this matter?
Yes,
Okay, and so anybody threatening you to make you waive these rights?
No.
Any promises being made to you in exchange for you waiving these rights?
no,
So you're agreeing to have judgment enter against you by consent, whereby you will vacate the property in question no later than November 30th, 2023.
correct.
And you understand that full compliance or performance is required. That means vacating means taking all of your personal items and discarding of all your trash and turning over the keys all by November 30th. You recognize that?
Yes,
Okay. And do you have any questions about that?
yes, I do.
What's your question?
I don't even know who I'm gonna turn the key to, or where to turn it to.
Okay, where does he turn in the key?
I can leave there at the apartment if they want me to.
Your Honor, I would pick up the keys if Mr. Scott would call the office ahead of time.
Sure,
Okay, so you'll make arrangements for that, sir?
sure.
Okay, and you should, you're gonna do a walkthrough or you're just gonna get the key? How do you want that to work out?
You can just get it.
Okay, and so you'll make arrangements to have him pick up the key. Do you have any other questions? Yes, I'm talking to you. Okay, you have 3 business days from today. If once you leave here, you realize you misunderstood the rights that I just advised you of that you waived, you can return to the court. You can request to have this consent judgment set aside. You would have to articulate how it was that you misunderstood your rights. And we'll set this matter for a hearing, okay?
Yes.
Mr. Keski, do we have your permission to sign your name to the consent judgment? You have-
Yes, I would request that permission. Otherwise, it'd be by hearing today, Your Honor. Mr. Scott, are you willing to have me sign the form on your behalf?
Okay, you're gonna have, I thought you were presenting a consent judgment too. Okay, Mr. Keski can provide the consent judgment and you're gonna have him sign the waiver. Okay, sounds good. Any additional matters for the record?
No, Your Honor, that's all. Thank you.
Thank you. You're all set on this matter.
Thank you, Your Honor.
Thank you.
Have a nice day.
Bye now.
Thank you. Bye.
Gone? Yeah, you're good.
Okay, who do we have here?
Jason Richardson, Samantha Kirchin. Randall. The attorney, I believe, is still speaking with his client.
And then Mr. Dewey's.
He's here.
Okay, sounds good. Norman is. Oh, got it. on the record in the matter of George Nicolopoulos versus Brandolyn Hale, file number 23-02166 SP. Council, may I have your appearance, please?
Good afternoon, Your Honor. Don Birch, appearing on behalf of the plaintiff, George Nicolopoulos, who is on Zoom. And I have an associate attorney, Patrick Simmons, too, who's filed in on Zoom, Your Honor.
Mr. Nicolopoulos is in the breakout room. Let me see if he'll come back. Today was the date and the time that was set for hearing. This is for a land contract forfeiture, and the parties have met, but there's been no resolution.
There's no resolution, Your Honor.
Okay, and what is the issue tying up the resolution? You don't believe that?
10,000 of back taxes that I found out after I had bought the house, and that's why I have not made my payments. He, in a text message, told me in June or July it was. I don't remember the dates of the pictures.
Okay, so
Told me they
there's,
would be paid, and they're still not.
okay. Now you can present your case.
Your Honor. Mr. Nicolopoulos, can you hear me?
Yes, sir.
You calling him as a witness?
Yes.
Mr. Nicolopoulos, can you raise your right hand?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can proceed, counsel.
Can you please state your name and spell it for the record? I'm not sure if you did or not.
George Nicolopoulos, Nicolopoulos.
And George, how do you know the defendant, Brenda Lynn Hale?
He started renting a room for me sometime in November of 2022.
And then there came a point that you and Mrs. Hale entered into a land contract. Is that correct?
That is correct, sir. That happened on or about February of 23.
In that land contract, can you describe the premises? I mean, what's the address?
1225 Regent, Lansing, Michigan, 48912.
Okay, and that is in Ingham County, correct?
That is correct, sir.
Okay, in just a second, George. Your Honor, I was prepared for this on Zoom, but Your Honor, I want to show you what has been marked or I want to mark it as Plaintiff's Exhibit 1, which is the land contract itself.
Okay, you provided her a copy already?
I have not. I will give her a copy.
Our original.
Well, you probably want to see what he's providing in court.
To show you and make sure that that's the same one. Thank you. Yes. George, you have a copy of the land contract in front of you, is that correct?
That is correct.
Okay. George, do you recognize that land contract?
Yes, I do.
Okay, and who are the parties?
Myself and Miss Hale.
You say yourself, the seller.
Yes,
Okay, now, it does say 90527 Living Trust, George John Nicolopoulos, TTEE. Is that you?
that's my trust.
Now, can you tell me, what were the monthly payments on this contract?
$800 a month.
And the purchase price was how much?
$90,400.
And again, this contract was signed when?
February of 2023.
All right, now the date on this contract says this contract made the 1st of March, 2023.
Yeah, it was the
You see
last
that-
day of February 23, March 1st. I think we
Okay.
met with her, yeah, it was February 28th. February 28th, was the date it was signed.
And George, you said $800 monthly. What day of the month were the payments due?
5th day of the month.
Was there any interest on that amount of 90,400?
No,
Was there any late fees?
no,
And the number of payments, installments, were how much?
113 installments.
And George, I'm going to refer you to the last page. Did you sign it?
That is correct. That is my signature.
It says George Nicolopoulos trustee.
Yes,
Okay, and did Mrs. Hale sign it?
yes, that is correct.
Okay, and it looks like it was notarized, correct?
Correct.
Your Honor, at this time, I move that plaintiff's exhibit 1 be entered into evidence.
Are you objecting to exhibit 1? Okay, exhibit 1 is admitted.
Now, George, when was the first payment that you got from Mrs. Hale?
I got the first payment in April.
April of 2023?
Yes, that is correct.
Now, the contract was dated March. Was there any payment made in March?
No. She needed a month to pay the security deposit on the utilities, so I gave her that.
And she paid April, and what other months did she pay?
May and June.
She paid May and June, okay?
Yep.
And so she has not paid July, August, September, October, November of this year, is that correct?
That is correct.
And if I do my math correctly, 800 times 5 months is 4,000, is that correct?
That is correct.
And now, Georgia, the land contract, who was responsible for the property taxes?
After February of 2023, she's responsible for all the property taxes. I'm responsible for everything before February 23.
And that is indicated on page 4 of the land contract, correct?
Yes, that is correct.
Under additional clauses, can you read that clause?
Seller is responsible to all property taxes till February 28th, 2023.
And George, are there any property taxes that were owed then prior
At
to
that
February
time, there were
20?
approximately $4,000 worth of back property taxes owed.
And George, have you paid that?
I've paid some of that.
And what is owed then? Is it about 4,000 or?
The 4,000
less?
is the back property tax.
And George, what is your intent to pay that?
I can have it all paid off by Christmas.
Okay. And also too, George, who's responsible for the utility bills
She
on that
is.
property? Now, is the utility bills, does it state that in the contract that she's responsible?
No, it does not state that in the contract. That was made very clear that she's responsible for the utility bills.
And you and Miss Hale talked about that you're gonna pay the utility bill.
That she's
Correct.
gonna pay the utility bills. That's why I gave her March so that she could make any security deposits necessary on the utility bills.
Now, the utility bills, are they still in your name? George?
Not at this time, as far as I know. But there was one, I got a utility bill in the mail from them that was somewhere in the tune of $1,700. Because she had not transferred the BWL bill over. She had transferred consumers, but not BWL.
And so, George, you're saying that there's an outstanding bill of 1,700 owed to consumers for electric, correct?
No, for BWL for electric.
Okay. George, have you asked her how come you're not paying?
I've tried. There's
What did
no
she tell you?
communicating with her.
Hey, George, is there anything additional that you want to add before I end my questions?
I'd like to get my house back as soon as physically possible.
Okay. All right. Thank you, George. Your Honor, no further questions for this witness.
Do you have any questions for this witness?
No, I don't know.
But can you repeat for me, for clarification, what is still due on the taxes that he said he'll have paid by Christmas?
Is there proof on one of them?
He says about 4,000 is owed on the property taxes. And that's prior to February 28, 2023.
Okay, Mr. Nicolopoulos, you still owe about 4,000 on the property taxes that was owed prior to February 2023?
Yes, that's the back taxes. Yes, Your Honor.
Okay, you've paid some on it already?
Yes, I can't tell you because I don't have the paperwork in front of me what I paid on it. I think it was like only $1,000. I think it was like 5,000 and I paid 1,000.
Okay, sounds good. Okay,
I guess
I was
Your Honor,
unable to work for a period of time because I have a heart condition and I couldn't go to work because my doctors would not clear me to do so.
okay, thank you. You had another question for your client?
Now, George, would you like is December, at the end of December, feasible to pay the property taxes, or is it more feasible like January?
We're not here to negotiate when he's gonna pay it off. I just needed to know. That's fine. You guys can deal with that another time.
Thank you.
No problem. Do you have any questions for him at this time?
Just for proof of what he's saying is owed on it, and does he have proof he paid those?
Okay.
Because that's literally what I've been asking is for proof.
Do you have any evidence, Mr. Nicolopoulos, of the payments that you've made on the property tax?
Not at this time, but only 4,000 is what is the back taxes, and I think we've both agreed that that's what's the back taxes. And I will
I don't
pay
know that
that
she's
by.
agreeing for that. She says she wants proof.
Well, I will pay that balance of the back taxes by the end of December.
Okay. But that's not proof that you made those payments, is what she's
No, I
asking
will
for. You're
make
asking
those
for proof?
payments.
Right. Proof that those payments were made, that he, that 5,000 and that 1,000, he said he paid. Where's the proof of those?
Okay, she just wants some proof that you have made some payments.
Well, that's a
Do you
matter
have
of,
proof of that?
I don't have that today. I can get it.
Okay. Okay, because your agreement or your contract does say that taxes and assessments levied on the premises must be paid before any non-payment. And then she would need to submit a receipt to you. Is that correct?
Yes, he would have to submit a receipt to me that she's paid property taxes.
Okay, and so, but you've not submitted any receipt to her that she's paid that you've paid property tax?
No, there's no receipts gone back and forth.
Okay, and has she made a request to you for a receipt?
No, I've never heard that request.
Okay, sounds good. Any other questions?
No.
Okay, do you have another witness?
I have no other witness, Your Honor.
Thank you. Do you want to call a witness or do you want to give testimony yourself?
I have evidence. I got this.
So you want to give testimony, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. Okay, so you believe that you did not effectively forfeit the contract? And your basis for that is because of what?
The back taxes.
You said there's a back tax bill?
Yes, I have. These were all delivered to our house. Obviously, I lived there. This was stapled on our door stating that if $8,694 was not paid by August, our house was up in auction in April, but that's already past due. So that's, as far as I'm concerned, already past due. That 8,000 was never showed to be paid. I went to the city and asked them. Right here's from, if not paid by 10/31, for $10,730 in back taxes on the house for the last 6 years.
Okay, so these are taxes that would have accrued prior to February
Prior to.
2023?
Yes,
Okay, and you have evidence of that?
yes.
Did you show him what your evidence was?
Yes, I did.
Your Honor, she briefly showed me when we were out there in the hallway. I'd like to have a copy. I don't have a copy.
I don't have a copy either. She can show you and then someone's gonna have to show me. I'm not
These are
making
messages
copies.
of me asking for proof of the payments of the taxes being paid, where I literally said I will do so to make a payment. I will do so after you verify that the taxes are paid. And text messages.
Oh, those
between
are
George
pictures
and
of
I.
text. Okay.
Yes. 3 separate occasions of that.
Sir,
Your Honor, may I take a picture of?
feel free.
That was literally stapled.
Okay, so I need to see these exhibits, but I need to know what they are one at a time. So the first piece of paper you have is what?
This is the back taxes that the city had stuck on our door.
So we're gonna call this Defense Exhibit A. Any objection to that?
No, Your Honor.
And what is the other document you have?
The tax delinquents for the 10,700, that's.
And that's Defense Exhibit B. Any objection to B?
It seems.
No, Your Honor. No, Your Honor.
Okay, A and B are admitted.
Those are the pictures.
And then I'll let you review those or take pictures if you need.
Somebody blood here for that.
You may.
This is Hale. I'm looking at those documents. It, now, what are the, like, what are the dates on it?
Or she knows we have them.
Those photos.
These are from June and July when I had stopped my payments. And him asking me for the payments, and I gave him a reason, and I gave him proof that if he verified something to me, I would make my payments on both of these situations.
And that's of this year, correct?
Yes. No, this was yes, this year.
Is that correct, you said?
Yes.
Okay. I know, no further questions.
Are you objecting to the photos being defense exhibit C? Are you objecting to that?
I probably need to ask my client if he sent those text messages.
Okay.
I know it's kind of hard.
You need to ask your client. Mr. Nicolopoulos look like he's text or typing something. Can you hear us, sir?
Yes, I can, Your Honor.
Then you're the.
That is George, that picture right there.
Hey, George, I'm looking at some text message photos. It says July 5th. And you state 49 days of work and property taxes is paid for.
Yeah,
You
that was for
correct-
1 year. 1 year's
Okay.
worth of property taxes. And that assumed that she would pay her $800. I made that very clear with a phone conversation that I had with her. And I sent the text message to verify that she understood what I was talking about.
George, also the text message, June 17th. You state, I've worked too hard to get that house. I'm not going to lose it. Do you
Right.
recall that?
Yes,
Okay.
exactly.
And she says, okay, I'll make my payment next month to them once they not you verify it's not going to be lost. Is
Right.
that her statement?
That is her statement. Had she been paying the $800 a month, there would have been no problems.
Okay, can you just answer the questions that's being asked, Mr. Nicolopoulos?
I'm sorry, I didn't understand I thought I was answering it correctly, Your Honor.
Well, you're answering them, but you're giving further testimony, and we just need you to verify that these are true and accurate text messages. That's all we're
Yes.
doing right now.
Yes, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Your Honor, no objection.
Okay, no objection to defense C. So right now, and I don't have those, you can provide those to my court officer. I have your exhibit A. This is a notice of show cause hearing and judicial foreclosure hearing for delinquent property tax. It says from 2022. Is that accurate?
Yes.
Okay, and then B is a Ingham County delinquent tax notice. Says tax year 2022, 2021, 2020, and 2019, there were taxes owed. Is that accurate? Can you say that so we can hear you?
Yes.
Okay, and that the amount at the base tax was $6,728.30 owed. However, it states if it's paid by August 31st, it's $10,530.59, and then it accrues a little bit more of a penalty if paid in September or October. Is that accurate?
Yes.
Okay, and then I have your exhibits C, which are 3 photos.
Yes.
How do I know which order these go into? Let's see.
The dates, there's dates on them.
Okay, it starts in June. Okay, so this one has dates, and then this one has July. This doesn't have any dates, so I don't know where this falls.
Okay, then I don't have a date on that one.
But
We printed.
what order should it go? I know obviously
June and
this one's.
July, I don't know what order that other one goes
Okay, let's
into.
see if
There
we
were
can
three
read it.
separate conversations. I screenshotted and printed.
Okay, and these are text messages between you and the plaintiff?
Messenger.
Oh,
Facebook
messages?
Messenger, messages.
Okay.
yes.
It says, all F, if you give them 800 a month till end of March, that's 8,000. That's, who's talking there?
He was trying to get me to send my 800 every month payments to the tax places instead of sending it to him.
Okay,
And that was prior to us figuring out what the total amount was.
and then June 17th, I've worked too hard to get that house. I'm not going to lose it. That's him speaking. And then the blue, that's your writing, you're
Yes.
responding on June 21st. Okay, I'll make my payment next month to them once, all caps. They not, you verify it's not going to be lost.
Once they verify that it was not going to be lost. I just wanted proof that it was not going to be in that foreclosure sale in April.
All right, so you sent this in response to notice of foreclosure?
For him, yes.
Okay.
He wanted me to send that payment. I told him I would once I had proof that it was out of foreclosure and out of that red zone of being taken. That's why I asked for proof, because he repeatedly said that.
Okay, and then I don't see the full message on this page. It doesn't have any dates. What I first see is people are sending me the money and I'll make the payment myself for the 800 and I'll provide you a receipt that I made it. If you don't have the whole 800, make a partial payment, please. They won't say no to a payment. That's Mr. Nicolopoulos speaking to you.
Yes,
And what was he speaking to you about?
the $800 payment because I had not made the prior months too. Prior month also because of the tax papers we were getting.
Okay,
So I wanted proof and he never showed me proof. And so then he asked for another payment the next month. He asked for payment again, and I told him that I would do so once I had that proof.
but my question is, it says I'll make payment myself for 800 and I'll provide you a receipt.
Yes, that's the 800 that he had asked prior to take to the city to pay. I said I would take it to the city and make that proof, but not once, not until I had proof that it was out of delinquent.
Okay, so his response is he'll make it the payment himself
Yes.
and bring you receipt?
Yes.
Okay, did you get a receipt?
I did not actually make those payments because I never got any proof of any taxes being paid, the 5,000 or the 1,000 that he says now that he still had paid. I never seen proof of those, nor did I get anything from the city because the city is working with me on this. I never had any proof of verification that anything was being made.
Okay, and I see your response. I will do so after, again, in all caps, I verify I'm not making a payment for no reason, and I will get that Tuesday. Is that what TUE means?
Yes.
Okay, they know I'm on it, so no worry there, and I'm not getting screwed. And response, I presume from Mr. Nicolopoulos, it was, I know you're not getting screwed, and then the rest is cut off. So I'll put it in that order. Any other evidence?
No.
Okay. Do you have any questions, sir?
I have no questions, Your Honor. Okay, guess I'd like to make a closing when that's appropriate.
Okay, well, I have some follow-ups for Mr. Nicolopoulos. Mr. Nicolopoulos, are you aware that there was past due taxes on this property from 2019, 2020, and 2021 and 2022?
Yes, Your Honor.
Okay, and during your direct, and by that, I mean, when your attorney was questioning you, you said that the bill was about 5,000, but you owe 4,000, but are you disputing that there's a bill that say that you owed $6,728 as of the date of this letter?
I don't have
Which was-
that letter, Your Honor, so I don't know exactly what's what. But I'm telling you what is to the best of my recollection.
You never received the Ingham County delinquent tax notice in your name?
No,
he never changed his address, and that's why the city took the tax program that he had, was using away, because he had moved and never changed his address with them, or was he supposed to sell the house?
Okay, so your client needs to see this. Not only does he need to see this, this is grossly different, this is problematic,
Understood.
because his testimony is that he hasn't paid it. So there's a $10,000 tax bill lingering. And he wants her to pay under the contract, but he hasn't satisfied his portion of the contract, which was that he was gonna pay all the taxes up until February 2023. And he's now saying on the record that he might pay it by January 2024. I'm gonna give you an opportunity to give him a copy of all these documents because he's not here, and talk about resolution before I make my ruling. Off the record. On the record, in the matter of Huntertown Properties versus Justice Livingston. File number 23-02300 LTE, council appearance.
Good afternoon, Your Honor. Corey Brand Mason, P 64392. I'm with Swiss Stack Levine and we represent the landlord in this matter.
Okay, and ma'am, your name?
Justice Livingston?
Ms. Livingston, you don't have an attorney, is that correct, ma'am?
No.
Okay, today's the day and the time that was set for hearing. And this is for non-payment of rent. I have here that the parties have entered a consent judgment. Is that correct, ma'am?
Yes, ma'am.
That's correct, counsel?
That's correct, Your Honor.
Okay, so that means you're entering judgment against you by consent, whereby you agree that rent to retain possession of the property is now $5,927 plus court costs of $167.50 for a total of $6,094.50, and that you will either pay that in full or vacate no later than November 30th, 2023. Is that correct?
Yes, ma'am.
Okay, you understand that you have the right to be represented by an attorney?
Yes.
Are you giving up your right today to be represented by an attorney?
Yes.
You also have the right to request an adjournment in order to obtain legal assistance. You technically had an adjournment because we had a pretrial already, but are you waiving your right again to that adjournment? Okay, then lastly, you have the right to have a trial by judge or by jury. We did not receive a jury demand from you or on your behalf, but are you waiving your right to jury trial so that you can proceed in this manner?
Yes.
Okay, and you signed this document?
Yes.
Do you have any questions about your rights?
No.
You understand that partial performance will not satisfy. You gotta either pay the entire amount of $6,094.50 or vacate on or before the 30th of November 2023. You understand that?
Yes.
You have 3 business days from the date of today to return to the court. If once you walk out that door, you realize you misunderstood the rights I just asked you about, you can request to have this judgment set aside. We can set this for a hearing, okay?
Okay.
Any additional matters for the record?
No, Your Honor.
You're all set, ma'am.
Thank you.
You're welcome.
Okay.
The record in the matter of Huntertown Properties versus Khalil Tanner and DeShayla Daniel, file number 23-02296 LTE, appearance for the record.
Good afternoon again, Your Honor. Pleases the court, Corey Brand Mason, P 64392. I'm with the law office of Swiss Stack Levine, and we represent the landlord in this matter.
And your name, ma'am? And your name? Thank you. And you don't have attorneys, is that correct? So, okay, today's the date and the time that's set for a hearing for non-payment of rent. I have a consent judgment here. It says that you are entering judgment by consent, indicating that you understand and agree that the rent to retain possession is $5,846.50 plus court costs of $167.50 for a total rent and court cost amount due of $6,014, and that you will either pay that in full or vacate the property no later than December 8th, 2023. Is that accurate?
Yes.
Okay, that's complete and accurate?
Yes, sir.
Okay, you sign these documents?
Yes.
Okay, and you understand that you have the right to be represented by an attorney today? Okay, and you've not appeared with their attorney. Are you waiving your right to counsel?
Yes.
Okay, you also have the right to request an adjournment to obtain counsel. You did have at least a 30-day, over a 30-day period of time from the time of your last court date. So you did already have an adjournment, but you're not seeking an adjournment at this time, correct? Okay. Yeah, okay. And then lastly, you have the right to demand a trial, and you can have a trial by judge or by jury. I don't have a demand for jury from you all. Are you waiving your right for a jury trial or a trial in this matter to enter into consent judgment? Do you want to have a trial or do you want a consent judgment?
I think I want to take the trial because I got proof of all the mold and stuff in my house. They telling me since I got no escrow account, it's nothing else to do.
Okay, you are alleging that there's an issue with habitability
Yes,
and that's the reason why you lawfully withheld your rent?
yes.
Okay, you've not made a jury demand, but we can't hold a hearing on that. Is that what you like?
Yes.
Okay. And do you have your evidence to support your claim?
Yes.
Okay, I'm gonna give you a hearing date. You need to bring your evidence with you, okay? And next time you come to court, go wear your bonnet. Okay? No, I'm just letting you know, you shouldn't want to come out in public like that. Very pretty girl, present yourself as that when you come out, okay? Okay, I'm gonna give you a next court date.
Your Honor, I would ask that if the defense of habitability is being proffered here today, in order to retain that defense by the time of the next hearing, that escrow in the amount that's currently owed be paid in order to receive that defense under the
Okay.
court rules.
I'll enter an order for escrow. You can complete the paperwork. I'm going to order that they place 1 month rent of escrow in within the next 7 days.
I got money orders right now.
From your past due rent?
I got money orders for my rent, like this month's rent, like in my glove department. Like I got.
Okay, okay.
I'll have to submit the order first, Your Honor, and then.
You're saying that you have your money tied up in a money order. Is that what you're saying?
Yes.
Okay. You can submit your order and I'll review it. Nonetheless, what's our next court date?
November 29th at 2:45.
November 29th at 2:45. Don't forget to bring proof of your evidence. And that doesn't mean you bring it on your cell phone. He needs to be able to see what you're presenting, okay? Okay, you do have a folder with evidence?
Yes.
Good. You'll bring that at the time of your hearing. If you can make copies of that, because you'll need a copy for him and a copy for the court, okay? Do you have any questions today? Any additional matters for today's record on this file?
No, Your Honor. We'll submit our evidence via email prior to. That's fine.
Okay, that's fine, but are you submitting it to them as well?
Yes, I will have more than one copy of it.
Oh, okay, sounds good. Thank you. You're all set. Kristen is dismissed. Okay, I see Marwan Hatem. Okay, you're representing Mr. Hatem? Who's representing Mr. Hatem?
That's that along. He sent a step along to third.
Folks, I don't have the file. Mr. Hatem?
Yes, ma'am. How are you today?
I'm good. How are you?
Fine, fine, Your Honor.
Your matter was adjourned.
On what basis, please?
There was a stipulation between you and the other party to adjourn it. So you would know the basis, I would not.
Okay,
Do you have an attorney? You're gonna wanna call your attorney.
Yeah, it's Mr. Levine.
Well, Mr. Levine submitted a step, he's not here.
Okay, I don't know why. He told me he was gonna come. All right, I'll talk to him.
Wait, hang on tight. Go ahead, Ken, versus Anderson. Oh, yeah, that is, the defendant's Matt is being represented by Madeline. Yeah, so, yeah, your attorney signed a stipulation to adjourn with the defense attorney, okay?
All right, then. Thank you.
Yep, no problem,
Thank you very much, Your Honor.
no problem.
Can I say something, please?
I'm sorry,
May I say something, please?
you can say something long as it's not about your case.
Ah, okay. All right. No, I was
Yeah,
gonna
you're
say something
represented-
about
You're
the,
represented by an attorney, and the parties are not here, so it would not be proper for you to say anything about your case at this time.
Your Honor.
Thank you.
Is that my office
Have a
or a
nice
different?
day.
building?
A different one. I wish they would put it that way on the docket too, because we have like four Levines in a row and then one of them's not your office.
Okay, I just want to be sure. We're very.
Yeah, it's not your office.
Yeah, we're very particular about things like that, particularly bad issues. So, thank you.
No problem. Mr. Jewett handled that one. I handled mine, stop, I still have the file. That was a consent judgment. Brandon and Hale, I sent them outside, and then I'm assuming this is Mr. Bernard
Yes, great.
Greer. Where's the attorney? Oh, I can't see. I just told IT that I can't see behind this. Okay, sounds good. Are we ready to proceed?
Yeah.
Okay, we're on the record in the matter of Woodside Meadows versus Bernard Greer, file number 23-0215 LT, council appearance.
Good afternoon, Your Honor. Mike Zappin, P 68107 on behalf of the plaintiff Woodside Meadows.
Okay, today was the date, you can have a seat, sir. Today was the date that we reset this matter at our last hearing. I was told that the property is pink tagged and was waiting inspection, but no one from Woodside had appeared. Is the property still pink tagged?
Yes.
Okay. So you're still, there's some habitability issues?
Yes.
Why is it pink tagged?
They don't have occupancy certificate.
Do you know why it's pink tagged?
They don't have a certificate for occupancy.
You don't have a rental certificate?
No,
I haven't had one since 2017.
This is not a rental then.
no, it's 2022.
That's not the information.
What's
that was
her name?
given.
So ma'am, state your name for the
Oh,
record.
Melinda Parrington,
Can you spell it?
FARRINGTON.
Council, what is it that you have there? You have some evidence?
I don't have nothing other than her testimony, the lease, ledger of what rent's owed. I think that the pink tag allows them to still collect rent or to be escrowed during that time that it's pink tag. He's done neither. So we're just looking for possession judgment because it is a total amount that we're alleging of $9,400.
Did you put your rent in escrow?
No, ma'am, I did not do that until, well, I didn't understand how that process worked. And when the last time I was here, you explained to me that this was civil, and I had to do all this stuff for myself. Then I had to learn about that. So the escrow, I had not been able to put money into that because what I've been doing is getting help from the state when I needed it for or MISTA or programs for when I needed.
For your past due rent?
Yes,
Do you
yes.
have a current application pending for assistance?
No, now I have a DHS for what do they call it? Emergency relief. I think it's called. I do have that pending, but,
You have, so I just asked you, do you have a current application pending? You said, no, I
not
have that.
from, yeah, not from.
No, right now. Do you have a current application pending for assistance?
For DHS, yes.
You
Sorry.
do?
Yes, for DHS, yes.
Can you print a form, please?
No,
What? Do you have evidence of that, pending form?
no, not in front of me, Your Honor, no.
Okay, can you get evidence of that?
Yes. Can I speak?
Well, I don't know yet.
Okay.
Because the court rules have changed since our last hearing. And so if you have a pending application, I have to stay the case.
What does that mean?
That means I have to stop the eviction if you have a pending application for assistance. That's what that means. So if you have a pending application for assistance, I'm gonna give you a form that you need to complete. You're gonna have to provide verification that you applied for assistance for the past due rent.
Okay.
It stops the case. I don't want anything else, unless you're telling me you don't have a valid rental application right now.
No,
Do you have
no.
something pending?
Yeah, but
Okay, that's all
I'm sorry, go ahead.
No, right now, like today. Is there something pending right now that?
Not for rent, I'm sorry, no, ma'am.
Okay, that's what my question was. Do you have anything pending now that will assist with your rental payments?
No, because I don't intend on paying, I do intend on just leaving, but I wanted to submit a countersuit first.
You want to file a counterclaim?
Yes.
Okay, and why have you not done so far?
Because I'm just, like I said, I don't know the steps on properly how to do it, and I'm still gathering the information and the proof.
Did you meet with legal aid at the time of your pre-trial?
They told me that they can't help me because my wife makes too much money.
Did you tell them about the habitability issues and that you needed assistance with filing an answer?
Yes, and they gave me the number to some guy that still I have not been able to get a hold of because they said they cannot assist me.
Okay, and your wife resides in this property?
Yes.
Where's your wife? Why is she not in court today?
Because she has the children and we did not have daycare.
Okay, and so what's the past due rent amount?
9,400, I'm sorry, renter retains possessions at $9,285.88. Cost of up.
That's all I wanted to know, past due rent.
Okay, I kind of want to dispute that.
Okay, what evidence are you providing to dispute that, and what evidence? What evidence do you have also that you're used to support that you had a habitability issue? And I recognize that there's a pink tag. The pink tag does let you either escrow your rent or you continue to collect the rent, although you're saying they don't have a valid rental certificate. Is that correct?
That is correct.
If they don't have a valid rental certificate, then that's problematic as well.
Yes, ma'am.
But I need some evidence of this. Do you have your evidence when do you intend to file a counterclaim? Because I'm not gonna put this out for you to file a counterclaim in January.
It can be before January. I just needed the time to collect the evidence, which I'm in the process of doing, because I didn't have access to the law school until this week. Now, my wife took a week off of work so I can be able to go in and access and do my own research. From what legal aid did mention to me is
you don't need to tell me what they mentioned to you because that's your own personal information. But you intend to file a counterclaim.
Yes.
And that's some evidence you want to use to support your counterclaim?
Yes.
Okay.
There are several
Is that code violations, what you're saying?
Yes.
Okay. And you showed them this already?
No, they have no contact with me whatsoever, even after before this, when I continue to put in my maintenance request and it either gets erased or marked as completed when no one has come to my unit.
Yeah, I did ask to meet with them prior to hearing today, not to waste your time.
Yes, you did.
Okay, well, you have some evidence that you claim support a habitability concern. If we're gonna receive evidence and testimony about your counterclaim, or if you're gonna file one, or at least your habitability issues, which you're using as a defense, I assume, to why you didn't pay your rent, then you need to provide them with a copy of any of that evidence.
Okay.
And then it would have been meaningful for you all to discuss what you're claiming is the habitability issue, or what you believe is the breach of habitability, so that you all can maybe come to a resolution. But it doesn't sound like that has happened.
Because that's not the only issue with the habitability. The other issue is,
So you're saying there's multiple issues?
yes,
You need to write an answer so that we are on notice
okay,
as to what all of the things that you're claiming. And that doesn't require you to go do a whole laundry list of investigation in a law library. I mean, you could do that to support your claim,
yeah.
but you should know, I would assume, since you've been living here, what you're claiming the issues are.
Yeah, no,
But
I
we
can
need
tell
to
you
know
the
what
issue.
they are, because it sounds like you have multiple issues,
Yeah,
okay?
no, I can tell you the issue.
Okay, but I want you to put them in writing for them.
Okay, put it in writing for them.
Yes, and then,
Okay.
and then you need to file a copy for it with the court.
Okay.
Because we've been here before and you never mentioned all of these things. Twice I've heard that the property was pink tagged. Well, today's the third time, but that's all I've heard. And now the list is growing.
Yeah, like I said, because I have to be my own lawyer.
I understand.
So I'm learning this as I go, ma'am, and I thank the court for you and your majesty for your patience.
I'm not your majesty.
Your Honor. Your Honor.
Your Honor's fine, thank you.
It's just as magical to me.
Oh,
But
thank you.
yeah, because I had to become my own attorney, I'm learning these steps as I go.
I imagine,
I'm
and they're
not
not
trying to
easy.
drag my foot. Yeah, ma'am, I'm not trying to drag my foot.
They're not easy, but I'm gonna give you a deadline now. That
Okay.
way we know that we're all being honest here. I am giving you leniency because you're representing yourself.
I appreciate it.
And that's the best that I can do. I'm gonna set this for a hearing. It cannot be on the 29th, because I think we're really having all these hearings on the 29th. On the 30th. November 30th? Yes. November 30th work for you?
Yes, Your Honor.
November 30th at what time?
10:30.
At 10:30.
Your Honor, can we request an escrow grant during the time frame, since the issues has been pink tag all along?
You can file a order for escrow. Thank you. Okay, and so there's a notice to appear for the 30th at 10:30. You are going to, however, file your answer, and or if you're filing a counter complaint, you're gonna give us that counter complaint no later than the 23rd, okay?
Understand,
So we know what you're claiming before you get here, okay?
understand.
Do you have any questions today?
No.
Any additional matters for the record?
Just if Mr. Greer wants to discuss anything after this, we're available for discussion. If not, then we'll just.
Very good. So they're open to some discussion out there if that's what you want to do. Try to see if you can come to resolution, okay?
Okay.
Thank you.
Thank you.
Oh, are we closing the 23rd? I forgot that's Thanksgiving. We need it to be the 22nd. You don't file it by the 23rd, file it by the 22nd, okay?
Okay.
Thank you. No, this sounds like he doesn't have a, yeah. Okay. Can I have those exhibits back? Unless you have a resolution.
We have a resolution.
Oh, okay, then I don't need the exhibits back. Okay, back on the record, in the matter of Nicolopoulos versus Hale, and the parties want to further discuss the matter, and now there's a resolution?
Yes, Your Honor. We have a consent judgment that is signed by both parties. I believe my client is still on. Is that correct, Your Honor?
He is still there.
And Your Honor, can I read the terms, please?
Yes, please.
Yes, I'm here.
Your Honor, this is a consent judgment. And it states that the plaintiff has a right to possession on March 1st, 2024. And the defendant shall turn over all keys to plaintiff's attorney when she moves out on February 28, 2024. Defendant does not have to pay any monthly installments, and defendant shall continue to pay the bills in her name, which are BWL and consumers. And just to be clear, there's $0, no money judgment for damages today. I guess I would like to say that, I mean, if there's damages after you leave, then I can come back and. Okay.
Okay, do you know what a consent judgment is?
Then I'm accepting you guys' terms. That I will be out by then.
No, judgment is entering against you and you're consenting to, in the, judgment's in their favor.
No,
Exactly, that's what you're consenting to that.
that's not what I want.
That's,
No,
But just a second, Your Honor, if I could.
no.
We talked about, no, she got, Mrs. Hale, if I'm, but no, you said, Don, I'll move out February 28th, 2024.
I don't wanna hear about the negotiations, because you can still, there's another mechanism whereby you can still get that, and it doesn't have to be a consent judgment. You could have did a conditional dismissal.
As I said, that's what I thought we were doing, was a dismissal of it, not someone wins this judgment by any means, no. That would be one of the harsh judgment against me, and that's not what this is. By all means, I proved what I needed to prove.
Well,
Well, I haven't made a determination about that, but nonetheless, you could still, you could do a conditional dismissal with all those terms, but she needs to waive all of her rights before she can do a consent judgment. And I don't think, based on what she's told me today, that she's gonna be waiving rights to do that. I don't think she understands what a consent judgment is.
understood, Your Honor. And then, I mean, that's probably my fault, but now I did want it on piece of paper.
We have
And-
forms for conditional dismissal.
Okay, we can do that. And then, that's right then, because now this will not be in your record.
Yes.
Okay, and then if my client is okay with that, but.
It'll be all the same terms that he was okay with then. It's just the case gets dismissed today. She's supposed to comply with whatever you put in there. If she doesn't comply, then you can make a motion to reopen the case and judgment immediately enters if she doesn't comply.
Okay.
That's how a conditional dismissal would work.
Sure.
Okay, so we can print out a conditional dismissal form for you.
Okay. And Your Honor, do we need to go back on the record or just return it in?
No, you'll come back on the record.
Not seen any of that stuff.
Okay, back on the record in the matter of Nicolopoulos versus Hale, and I have now a consent order for conditional dismissal. It states here that the parties want the case dismissed today upon the condition that you, Ms. Hale, will vacate the property and turn over sole possession no later than February 28, 2024, that you will be responsible to have all other occupants out on or before that date and time as well, and that you will turn over all keys to the premise to the attorney Birch when you move out, and that you will continue to pay all the bills that are in your name, which include Board of Water and Light and consumers. and that you do not have to make any monthly installment payments under the contract. Is that the terms that you're entering into for a conditional dismissal?
Yes.
Okay, and I recitated that accurately.
That is correct, Your Honor. If I could ask my client if he agrees.
Okay, Mr. Nicolopoulos?
Yes,
Okay,
Did you hear those terms, Mr. George?
yes, sir.
Do you agree with those terms?
Yes,
Okay, and I have signed it as your attorney, okay?
okay. And so you understand that partial performance, ma'am, will not satisfy that. That means that you have to perform to the T, everything that's stated here, meaning you're vacating, you're getting all of your possessions out, you're bringing all the people that you had living in there with you out, you're turning over the keys, and you're paying all the bills that you're responsible for, including the Board of Water and Light and Consumers. And you're doing all of that before February 28th, 2024. You understand that?
Yes.
So if you don't perform fully, that gives the plaintiff the right under this agreement to have the case reinstated, and then immediately judgment will issue against you if you don't comply, okay? Okay, do you have any questions at this time?
No.
You have the right to be represented by an attorney at today's hearing. You did not appear with an attorney. Are you waiving your right to counsel to have this matter dismissed by consent or conditional dismissal?
Yes.
You also have the right to have a trial by judge or by jury. Did you want to waive your trial?
Yes.
Okay, anybody threatening you to get you to move forward in this direction?
No.
Okay, you have 3 business days from today. If once you leave here, you realize you misunderstood the rights that you just waived, you can return to the court. You can request to have this conditional dismissal set aside, and we'll proceed with your next hearing, okay?
Okay.
I'll get you a copy of this document, and then you'll be all set. Any additional matters for the record?
No, Your Honor. Thank you very much.
Thank you, you're all set. When very much.